I find the timing of the court's recusal in my Kenton County Family Court litigations to be very interesting and deeply troubling. Why do I think that? I think that because we are in the middle of a long hearing in one of those cases that took place on October 8th, and which I'm pretty sure did not go the way that those who wanted to have it wanted it to go. And during which deeply consequential, deeply troubling, deeply problematic procedural defects in the proceeding were brought out into the open, one after another, over and over again, over the course of a 4-hour hearing. And the hearing is public record. It can be viewed by anybody. So, nothing that I say on here is like my opinion. It can all be verified. It's all just what it is. How in the hell can you transfer a case? Can you recuse in the middle of a hearing? And the reasons, given for the recusal, while, not very flattering to me, I think by any standard seem a little bit strained. Look, this is what happened. I caught a judicial staffer and a private actor with their hand in the cookie jar in a very consequential way. You had a judicial staffer granting, playing judge and, manipulating the docket, doing something that only the judge by rule could do. And on behalf of the judge saying yes to a special friend of the court, special lawyer, off the record, outside the public view, in the dark. And because there was objection made to that by me, the court coming back later on, and per the judge, that same judicial staffer, probably knowing that I would make an issue of that, Katie would make an issue of that at the motion docket, as we have in the past, clearly went to the judge and, kind of probably ran by the judge what that judicial staffer had already done. And, the judge said no, and got it right and applied the law. And application of the law meant that it dictated the result that what the judicial staffer had given to that private attorney, our oh so special friend, that whose actions permeate all these videos, sadly, that what had been given by that judicial staffer to that private attorney was not warranted under the law, under the rules. And so it was undone. And that is the email string that I put on the internet. It's naked, okay? It's stark, it's stunning, it is what it is. Those that, if those engaging, if those actors want to somehow, try and explain that or act like it's no big deal, it's just simply ludicrous. It's right there in black and white. And there's plenty more examples of that, but that happened to be the most recent one, and I put it on the internet. And I have been saying over and over again for many months, my goal is to cease this stuff. It is to bring it out of the darkness, put it into the light, let the people judge it, and let the people have a reaction. And the people have spoken. And they've certainly spoken to Katie and I. I had no idea that there was this layer of, righteous indignation laying right below the surface. So many people, including lawyers, who have put up with this shit for so many years, who are tired of it. I mean, really tired of it, pissed off about it, know it's wrong, but we're not in a position to do something about it. And all of these people who have been hurt by what they recognize as a system that operates like that, I didn't know that existed, and the objections that we've made and the stand that we've taken, it was just, kind of almost just lighting a match and throwing it on the ground that was laced with kerosene, and boom. I mean, these people were waiting for a spark to start this revolution. I didn't really know that. I'll be honest, I didn't know that. But here's where we are. But you have a hearing now where bit by bit, all these things come out. You have the public face of the family bar in Kentucky admitting on the record that she filed a paternity case before the child whose paternity was to be adjudicated was even born. Now, there's only two reasons to do that. One, you have a very inexperienced lawyer who just apparently doesn't know that you have to wait until a human life is born before you can file a lawsuit to adjudicate the paternity, which is a matter of logic. That's clearly not the case here. The other reason is you're trying to manipulate the system. You're trying to, time your filing such that you draw a certain judge. And you're trying to forum shop, is what we call that. And if you're doing that, it is certainly consistent with the idea that it is very important to have a certain judge because you will hook up with that judge's staff attorney. It fits hand in glove with, I don't even know that you would call it a working theory anymore in light of the recent proof. And the other stuff that came out of that hearing. That is a bombshell, okay? The emails with the very same lawyer and the judicial staffer that I put on the internet are a bombshell, okay? And, frankly, the fact that an order was written back in April, subsequently circulated to, all of my contacts multiple times with, hate notes in there saying that, Ben has a mental illness and don't listen to him and he's lying, okay? An order back in April was issued. That is a 20-page, single-spaced order issued 6 days after the parties submitted their 15 pages each final briefs containing their facts and arguments. Those 6 days, including 3 days of Easter and 2 other days where the person who writes the orders and the judge himself were otherwise occupied on the bench, leaving 1 day, even if it was 6 days, but 1 day to read both parties' briefs, consider their factual and legal arguments, and write a 20-page single-spaced opinion, absolutely blowing up one of the litigants, stating on the face of the order that the order was written for a lot of other people besides those litigants, containing findings of fact borrowed from other cases, referencing material that had not even been mentioned in that litigation, begging the question, where did you get that information? Because it's not in the record. Nobody talked about it. There's no evidence on it. 40 or 50%, 40%, I think, of the findings of fact being in some way, each one, objectively wrong. Stupid things like, the parenting time schedule I have with my other kids. I mean, it plainly reveals, as a matter of logic, that opinion had to have been written substantially in part before the parties even submitted their post-trial briefs, their arguments in the case, factual and legal, that the case was decided in advance. In other words, the case was fixed, which just happened to be what both the opposing lawyer had told my lawyer just before the trial, and very frankly, what I felt like I was being told before litigation broke out by the other party herself. So, these are bombshell things, and that's only a handful. And all of these are out, and we have a proceeding on October 8th, and we are right in the middle of that, okay? And at the end of that hearing, it's abundantly plain that, the staff attorney communicates only with that attorney, again, the same attorney, all right, does not communicate with, our side, Katie or myself. That's ridiculous. That is ridiculous. I mean, whatever partiality is, that's it. Has done so over the course of, 2 litigations spanning 2 years, a total of 126 court orders. I mean, just starkly disparate treatment. Arranges the docket in such a way that only one side's motions really are heard, There are motions pending about key issues, really key issues, that have been pending for over 2 years, while the other side has all their motions heard. Again, the same lawyer, okay? The staff attorney, same staff attorney in charge of all this. I mean, all that stuff is brought out into the open. And so damaging is that court hearing, and so fearful is that lawyer, that this stuff is going to make its way into the public domain, that literally at the end of that proceeding, that lawyer moves the court for a gag order, which is an extraordinary thing, really intended to make sure that juries aren't polluted by, media dissemination. This is not even a jury trial thing. I mean, it's just a dramatic, desperate grasp to prevent the public from finding out what happened at that proceeding, knowing correctly that Katie and I are going to go on the internet and we're going to show the people. I mean, so dramatic was that, the evidence, the things that came out into the public domain at that proceeding over a 4-hour period. So damning and damaging. And so evidently, nefarious and manipulative and violative of the rules and the law was the information that came out at that proceeding. That party, okay, who understood their goose was cooked. And not only that, the goose in the form of the staff attorney at the court. And that hearing doesn't get done. And it's continued until December. But the writing is on the wall. Okay? And I can't imagine that anybody associated with the court would want me in that courtroom picking up where I left off on October 8th. I mean, if they wanted to gag what happened the first 4 hours, oh, buddy. I mean, we all know what's coming right here, and it ain't good. And it's going to be more of the same stuff, and more of this stuff is coming into the public domain. And then it's going on the internet. And that is the posture of the court's refusal of my cases. And so, having made damn clear that I ain't going nowhere, having sanctioned me to hell and back, having taken one of my kids away, having put up with absolutely just, I'm sorry if people don't realize this, or the guardian ad litem doesn't realize this, but this is rankly, flagrantly unlawful conduct, okay? Having put up with that stuff. Having entered an order saying that I cannot file motions, which is as constitutional thing as I've ever seen in my career. And I feel like a first-year law student can pull up the case law and understand how, it's just like turning off the judiciary for certain, with all due respect, you can't do that. Having done all those things and not having been able to shut me up, and having a hearing, and frankly, me bringing these things out into the open, all of this shit, faced with the prospect of coming back in December, me putting a Facebook video, posting a Facebook video that absolutely lights up the two people engaging in this, the two people who engaged in the email correspondence, which is on its face horrible. Horrible. Pisses me off as a lawyer to see any other lawyer doing that crap. Pisses me off to see that it worked for a second, and that private lawyer was going to get stuff that only the judge could give by rule, which the law didn't authorize, but which she got for 30 minutes, courtesy of that staff attorney. It's right there in the email. I'm not having a debate about the facts here. It's right there. And you have a private lawyer, private citizen, see that, put that, and just absolutely go off. Hell yeah, it went off. On behalf of the people of Kenton County, and very expressly on behalf of the people of Kenton County. And I don't know, I put some pretty direct videos on the internet before. It's hardly the first Facebook video I posted. I don't know that, some of the other ones weren't, equally strident, In any event, it just is so curious. It just seems like quite a reach to pick that moment to say, Ben was a meanie pants. We can't hear his case. He's a bully and he's threatening us. We recuse. When the effect of that recusal is to, in the middle of a hearing at which all of this evidence has come out about the procedural improprieties, one after another, bombshell after another, big one after another. I mean, kaboom, 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 to the point where there's literally, it's so damning that, the attorney who is engaged in this stuff asked the court to bar us from telling the public in the form of a gag order to take. It has the effect of the hearing likely won't continue. How do you have a different judge come in mid-hearing and continue a hearing? Can't do it now. We can't do it now. And I find that incredibly interesting. That is some interesting timing. And, I've seen way too many coincidences in this thing. Okay? That staff attorney, we were getting, the heat was coming the flames were licking pretty close. And they correctly perceived that if I was in that courtroom in December, I was going to bring the house down. The house with the truth, with the law and the facts. We were going to pick up where we left off. It was pretextual. Yes, it was. And all of these things that I was now going to put in there, that they saw coming, now they don't have to endure that. And the evidence that has already been part of that hearing may, in a way, be pushed back into the bottle if we can't continue that hearing. I don't know. To recuse in the middle of a hearing, a 4-hour hearing, the most damning hearing in the history of the Kenton County Family Court in terms of revealing the procedural impropriety of that place. Boom, ba-boom, ba-boom. That's when we're going to recuse? I've been asking for disqualification for years. That's when you're going to let me out of jail? I just think it insults people's intelligence. And I thought people should understand that. Thanks.